Good morning, good afternoon, and good evening, wherever you are and whatever time you see this video. We have a special guest with us, Sanjoy Ghosh. He's an attorney from Delhi, and he's originally from Calcutta and studied in Bangalore and settled in Delhi right now. So he has experience all over India. So welcome to the show, Mr. Sanjoy Ghosh.
Thank you so much.
You're welcome to the show. So we would like to know a little more about yourself. If you can, we really appreciate if you can tell us more about yourself, please.
Well, briefly put, I studied law at the National Law School of India. I am from Calcutta, but I studied law in Bangalore, which was the first national law school set up in India. Thereafter, I have mostly been in Delhi. I practiced in the Supreme Court as a junior of Miss Indira Jaising, who's a well-known lady senior counsel. Thereafter, I practiced in the Delhi High Court. As of now, I'm in the Delhi High Court. I am the standing counsel of the Delhi High Court. I'm also the additional standing counsel of the Delhi government in the Delhi High Court. And I've also been doing a lot of labor matters and cases for women who face violence, domestic violence. So I think that is enough about me.
Gotcha. I know you. Very nice of you. I mean, you've been dealing with many cases. When we looked at your on your website, I mean, you've been dealing multiple cases. That's very nice of you saying a few things about you. And can you tell us, I mean, how is the pandemic in Delhi in general, and how is it affecting the judicial system in India?
That's a very important question. It is the most important challenge I feel the judiciary is facing. As you know, that the right to a judicial remedy is the most basic of fundamental rights, legal rights, constitutional rights. And it has been said it's the mother of all rights. So in a situation where the general citizens, public cannot access courts, it becomes a great challenge. Physical courts, especially in big cities like Delhi, Calcutta, Bombay, Madras, is becoming a challenge because, as you know, the COVID pandemic is in full blast. Some courts like Madras and Calcutta tried to open physical courts, and then honorable judges and court staff got infected, became COVID positive. So most courts are trying to deal with the situation by innovating with technology, by having virtual courts. So the honorable judges are sitting virtually. Links are being given, like we are doing this interview through link, and the parties are presenting their case through the link before the judge, and it is a virtual proceeding. Of course, with time, it is being innovated, and now even journalists and even members of the public can also seek to be given access to these proceedings. So in one way, it has brought about the transparency of judicial proceedings, which people are wanting for a long time, but in very, very unfortunate circumstances. That having been said, one thing which is important to say is that there are limitations to this system because, as you know, there is a bandwidth issue, there is a logistical issue. So in India, when each court is dealing with, let's say, there are 23 courts in the 34 courts, let's say in the Delhi High Court, each court deals normally with 50 cases a day. Now, in a pandemic situation, to actually transfer and translate all of that into virtual proceedings is a very, very difficult issue. We started off with limited cases. Gradually, the scope is being expanded, but there are limitations of virtual proceedings, and most of the cases are actually getting adjourned since March. And now the recent adjournments the courts have now been adjourned till 15th of July. We don't know, and most likely, again, it will be further adjourned because I don't see by 15th of July the situation improves. So yes, the pandemic is creating a great, great crisis for justice delivery. As you know, already we have piling arrears of cases in India.
Oh, very nice. So what are the challenges? How do they deal with the evidences? Let us say, some cases they may have to show the evidence. How are the documents to the judge or submit to the court? So how are they dealing with those kind of situations right now? I mean, if it is only the verbal arguments, we can understand. But the evidence and those, how are they dealing with the details of the case?
That's also a very important question. What has now been done is certain courts like the Delhi High Court has framed video conference rules, and they also provide how evidence has to be recorded through video conferencing. As a matter of fact, you may be aware that even before this pandemic, in certain cases, evidence was already being recorded through video conferencing, especially when witnesses were away from the place where the evidence was being recorded. For example, let's say in a case in the Delhi High Court where the witness is sitting in Cincinnati or New York, already that was happening. Now courts are making rules. Also, family courts recently in Delhi have opened up. Now even divorces are being given, and family court proceedings are also being done through virtual proceedings, through virtual court proceedings. So evidence is being recorded, decrees are being passed through virtual court. There are of course issues. About this, but well, this is what we have to make the best of whatever fate gives us.
Gotcha. Okay. So what kind of, do you know any, can you help us out in understanding what kind of cases are they taking up right now? Are they taking everything? I mean, you said there are some cases they will not be able to take it. General, yeah.
What has happened is that most of the courts, including the Supreme Court, have come up with a list of cases which they are considering as urgent cases. So, for example, a death sentence, a demolition, or an execution, or some kind of urgent relief, say hospitalization for COVID patient. So each court is coming up with these list of urgent matters, and currently only these urgent matters are being heard. Those cases which are not deemed to be urgent are unfortunately getting adjourned repeatedly as the lockdown is being extended in whatever form.
No, okay, I got you. Thank you very much for giving us the inputs on those, the situation, how the judicial system is handling the cases, and the kind of cases they are taking up. So, I mean, coming back to the normal life before COVID or after COVID, I mean, in India, you are special. How are the labor laws? I mean, we have been hearing about the labor laws in multiple contexts. One is one side, the labor laws which are not favorable to the labor or employees, and another side, I mean, we are been hearing about the because of our labor laws, I mean, foreign companies are not coming into the coming to the country. I mean, our country. I mean, they're not able to invest money in the country, in India. So how do you see these two? Like, I mean, one is, I mean, labor unions are demanding more benefits or more perks, those kind of things. And the other side, I mean, the foreign FDI is saying that, I mean, because of your labor laws, we are not able to come inside. It's not favorable for us to invest in India. So how do you see these two things?
India has a plethora of laws. We have plenty and plenty of laws. What is missing is proper execution. I have been a labor lawyer for more than 20 years, and I can tell you, and I've represented the workmen and the management, the good labor and the good employer are the ones who always suffer. The clever laborer and the clever management or the employer always knows how to play the system. So as a matter of fact, there was a move by this government to simplify all the labor laws, hundreds of labor laws, into 4 different codes, to batch them, one dealing with all the wages, one dealing with employer-employee relationship, one dealing with industrial safety, and one dealing with the welfare benefits. Now, sadly, that has got stuck in the legislative process in the parliament, in the Indian parliament. It was some of them were introduced. One code the wage code has already been passed, but it has not been implemented. The industrial employment relation bill has been introduced in November, not yet passed by parliament. Now, in all this, when a process of simplification of labor laws was being done, the COVID pandemic hit us. Now, unfortunately, the responses of the central government and many of the state governments have not been proper and have been universally criticized both by employers and by the workmen. And I will explain how. As you are aware, in the US, the first thing the US government has done has given all the small industries some kind of bailout, a relief package, whereby they are able to cover the salaries of these employees in small establishments in the US. Now in India, what we have the MSMEs, the medium and small scale enterprises. Unfortunately, that has not been done. First, the knee-jerk reaction of the government was to issue directions under the Disaster Management Act, directing that during the pandemic period of lockdown, every employee has to be paid their wages even if they work or don't work. Most likely they will not work. Now, that is a very noble idea was behind that, and we must congratulate the government for doing that. But unfortunately, that was only a single intervention without also simultaneously giving a package of relief to employers to be able to tide over the circumstances, to be able to pay these workers, to be able to get a loan, or to be able to somehow manage their units. So what happened was that this directive that all workers should be paid was not implemented. As a result, you may have also heard in America, and you must have read in the social media, large-scale workers who were not given any wages, who could not pay their rents of their houses, had to leave the cities, big cities, and march and walk all the way back to their rural areas from where they came. Of course, subsequently, the government woke up to this huge problem of migration, and they came up with the Shramik Express, these trains which took them back. Now, in all this, what happened was certain states thought that the best way is to give an atom bomb in the hand of an employer. So what, for example, the state of Uttar Pradesh did, which is a North Indian state, is they proposed to do away with all labor laws for 3 years, which was absolutely ridiculous. Because what it basically said is that there will be no law and the employer can just hire and fire. Now, that was completely contrary to all what has happened in India, including the constitutional right to form unions, because even the Trade Union Act was suspended. The right of Provident Fund, the right of gratuity, all these valuable rights of workers were also taken away. Mercifully, that proposal, that ordinance of the Uttar Pradesh government is still not being cleared by the central government, which has seen wisdom in preventing this kind of knee-jerk reaction from happening. So as a result, what certain states have done is certain states have relaxed certain labor laws, like they have brought down the minimum wages like Punjab has done. They have extended the work hours like Gujarat and Madhya Pradesh have done. They have tried to increase the work day as Orissa and Uttar Pradesh have done. But unfortunately, unless there is an effect hand-holding in the form of giving an economic incentive to the employers, I believe that all this will only lead to more unemployment. It will only make it easier for industries to close down without giving any compensation, without giving any kind of package, any kind of closure handshake to the workers, the employees, and it will lead to a massive unemployment in the future coming days. So the need of the hour is to think creatively of how to reform the labor laws. No one, not even the workers and trade unions, can seriously dispute the fact that there are too many laws and that these laws prevent a decent employer from actually starting his business and running it. The solution is not to throw the baby with the bathwater. The solution is not, oh, we have too many laws, so do away with all laws. The solution is to find that middle path with the cooperation of all the stakeholders. This is the time when you have to take all the trade unions on board, you have to take all the employers associations on board, and we have to swim or sink together. Otherwise, I'm afraid the industry will not survive this pandemic.
Yes, I mean, thanks for the explaining on all these things. I mean, we were not aware of different states had different policies, some different rules for the labor. I mean, extending the hours or the minimum wages and those kind of things. I was not aware of it in the beginning. But if you look at the China or other places, I mean, even US, I mean, the free market. I mean, okay, they put the minimum wage, but at the same time, if you have the minimum laws, I mean, the free market is the one which is driving, and also the wages are going up in the free market because of the competition, because more employers are coming in, and indirectly they will be creating the demand for the employees. So I mean, when there is a demand, I mean, obviously the wages will go up. So in spite of the minimum wage, I mean, the wages will be better than the minimum wage. So don't you think so? I mean, that will the free market will help in increasing the more opportunities and more employment and drive the salaries up.
Let me tell you there can be no disputing what the proposition that you are saying. And ultimately, with all these laws for so many decades, it's not that the labor is some, pampered class. As a matter of fact, this has actually prevented the formalization of labor. And you may be aware that not even 10% of actual workforce is governed by all these laws. Most of the workforce in India is the informal and unorganized sector for whom these laws don't apply at all. So what you're saying has a point. But there is also a counterpoint which you have to keep in mind. You see, when you speak of America, or let's say the United Kingdom, of course you took the name of China, I'll come to China later. The United Kingdom, the European Union, America, the economies which are free market, as examples you're giving, also simultaneously have two things which are very important. One is a very effective compliance of labor laws. So whatever labor laws, industrial safety standards, benefits are there, there's a very strict compliance, not only in the form of enforcement, but also in the form of voluntary compliance by employers, because they are scared of the law. They fear the law. Now in India, no one fears the law, unfortunately. That's the tragic reality. So there is no compliance of these labor laws as you have in these societies. The second point which I was going to say about these societies is that they also have a very vibrant social welfare scheme. As you know, in America, where you are situated, so many people after the pandemic have gone into unemployment benefit, right?
Yes.
In India, we don't have that kind of fallback. So therefore, it may not be actually fair to compare these economies and just blindly apply the free market doctrine in India without providing for the circumstances which I was telling you about. And also keep in mind that India has a different constitution. The Indian constitution guarantees the welfare of all citizens, especially the workers. So therefore, there is a constitutional protection also. For example, unlike China, I don't know the Chinese constitution. Most communist constitutions are very good on paper, but whatever it be, the Indian constitution guarantees a right to form a trade union. So how can you, when the constitution is saying that you can form a trade union, how can you, by a law, say that for 3 years trade union act is suspended, there can be no trade union, there can be hire and fire. Now coming back to minimum wages, I just want to give you one small example to explain how law is so easily misused in India. You see, there was a Minimum Wages Act which provided for payment of minimum wages, but no one followed it, or most people didn't follow it. So the government tried to be smarter than the people. So what did the government do? The government came up with a legislation which said, okay, boss, now you have to pay your minimum wages through bank transfer. So then, once it's through bank transfer, it's very clear. It will go to that account of the worker, and the amount you're actually paying is also known through bank transfer, which is a very revolutionary step taken by the government. Now, do you know what most of the employers did? They entered into an agreement, an informal arrangement with their worker by saying that, look, in the morning, I will transfer this money to you, but in the evening, you will go to your ATM and you'll withdraw that my commission and bring it back and give it to me. So this is the situation that is there. So however much we make laws, or it may sound that, oh, we have so many laws which are giving so many goodies to workers and employees, but in practice, in implementation, there is a lot of slip between the cup and the lip.
Gotcha. I mean, what I understood, I mean, from your views, I mean, are the points, I mean, I see is, I mean, the lack of social safety network in India, and also the lack of government not able to implement these things. The government is forcing the private sector to take care of the employees, and which is kind of forcing not new companies coming in, and not creating the demand in the employees. If there is a let us say, I go, I'm a layman, I'll go with a very simple example. And the metros, I mean, in the cities and metro, most of the metros in India, let us go with the housemaids. I mean, we have seen many WhatsApp videos. I mean, how valuable is a housemaid in India right now. I mean, if she doesn't come for a day or two, I mean, you have to. I mean, everybody will be I mean, panic. They get panic and they go. The whole life can chaotic. So there is a demand. So because I mean everybody wants it. So if you create the demand, that kind of a demand, I mean obviously the employer will value the employee and they will take care of the employee. So why can't I mean government try to understand that logic and then try just instead of appealing to just the trade unions and some of the votes, they are these are my views. I mean they are only trying to appease and appeal to the some of the labor unions and try to get the votes. They are not able to change the labor laws. That's what my feeling is. And
you are right. You're absolutely right. Do you know that when the Supreme Court in 1983, 82-83 gave a very wide expansion or definition to industry in the Bangalore water supplies case? Earlier, the Industrial Disputes Act, which is the most important act, only governed real factories, which with chimneys, furnaces. You understood what a factory, what an industry is. Now, the Supreme Court in 1983 gave such a expansive definition saying any systematic activity carried on with the cooperation of the employer and employee to produce goods, distribute services is industry. As a result, Tirupati's temple became an industry. The Safdarjung Hospital became an industry. The Bombay Gymkhana became an industry. The Parliament enacted a law immediately in 83 to do away with this wide definition of industry because this was going to create havoc. But do you know that definition, which is enacted in 83-84, till date 2020 has not been brought into force by the government, any government? We've had so many governments since 83, Indira Gandhi, Rajiv Gandhi, BP Singh, Narasimha Rao, Atal Bihari, Modi ji. No one has brought this law into effect. That is you're absolutely right, that people fear that there are trade unions and these are vote catchers and it will be very difficult if we try to take any unpopular step. But the fact of the matter is that at the end of the day, it is not that it is helping either the employer or the workers.
Oh, okay. So what do you see? I mean, where do you think? I mean, we should. You've been, as you said earlier, you have been handling both the employers in some cases and the employees in some cases. Where do you see a balance between these laws? I mean, who should? I mean, where should we stand? I mean, what is the balance between these two groups?
See, the balance is, you see, in India, in Indian labor laws, the most important restriction which the employers feel is unlike, and people in America will not even be able to believe this. But in India, you may come and set up your business, but the law prohibits you from shutting your business until the government gives you permission. So these are exit restrictions on industry. Those were made in the 1940s, 50s, 60s, keeping the socialist economy in mind. That once you set up an establishment with more than 100 workers, you can't close that industry because the workers will be unemployed. You have to go to the labor department, and the labor department would, because they're all scared of votes, popular leaders, trade union netas, etc. Hardly permissions are given to close industries. As a result, the employer who does not get the permission then has to challenge that rejection order in a court, in the High Court or Supreme Court, and fight for years. And all the while will have to keep paying these workers, though the factory is bleeding. So this is something which I agree should be revisited. The closure norm should be revisited. But at the same time, we have to take steps to give certain basic protections to workers, including bringing a lot of these informal economies employees into the formal sector. I can tell you one simple thing. All labor laws talk about benefits of workers on the basis of two things. One is your salary as on the date of you being removed or laid off or retrenched, and second is the number of years you've worked. Often there is a dispute, and most of these cases in courts are on this. People say, oh, he's not my employee, or that, okay, he's my employee, but I was not paying him $100, I was paying him $10. Or he's not worked for me for 5 years, he's worked for me for 3 years. So this is a very simple thing. In informal economy, they don't even give any kind, they don't even maintain any kind of records. In the formal sector, you're supposed to maintain records, registers, that also those muster rolls are fabricated. Now, if the little thing we can do is require by law that every employee has a right to get an appointment letter. It doesn't cost you, it is just one piece of paper which says, yes, you are an employee, this is the date of your employment and this is your salary. I think that will go and make a revolutionary change in protecting the rights of the employees. So when ultimately you want to close, give them permission to close. But when you are closing, at least give the right compensation. At least the right calculation should be done. At least the right people should get compensation. Today, even this basic thing of requiring to give an employment letter is also not there in Indian law. Though we have so many laws, so many rules, so many regulations. So let us start with baby steps.
Yeah, I got you. I will be switching the topic to another area like the IT sector where there is no trade unions and right now, and I'll go to another topic called non-compete and then the notice periods in the IT sector right now. So how is that non-compete is in India is working and especially in the IT division. I know in the manufacturing side and because of the patent and other things they may how I are able to implement it. But I mean, I'm not very familiar with that area. But IT sector, what do you think? What kind of cases you're seeing in the non-compete? And first, let's go to the non-compete, please.
Well, I have been advising several IT companies and also on the issue of non-compete. I can tell you one thing that it is joked in India that maybe the IT sector is doing well because there are minimal regulations and minimum laws. So where there are least laws, the economy, that sector does well, which is a sad commentary on a legal or the economic regulation system. Coming to your question on non-compete, see, Indian laws are very vague with regard to non-compete, in the sense that an agreement in restraint of trade or employment under the Indian Contract Act of 1872 is considered wrong. Is considered, for example, the Contract Act prohibits certain things. Like, for example, you can't have an agreement in restraint of marriage. You can't enter into an agreement that I will not marry your girlfriend. Those kind of agreements are considered illegal. Similarly, you can't enter an agreement that you will not work in that place. That agreement is considered wrong. So non-compete clauses are enforced by courts, but the courts will see how fair those non-compete clauses are. For example, let us say one non-compete clause says you will now not work for the next 10 years. I'm giving an absurd example just to explain the thing to you. The court may say that this kind of non-compete clause is absurd and it is so oppressive that it is going to cause grave injustice to the employee. For 10 years, you can't work anywhere else. Then the court may not enforce such a non-compete. Similarly, for example, a non-compete clause gives such a wide thing that you can't compete in A, B, C, D, E, F, G, or makes it so vague you can't compete in any business which is similar to what I have been doing. Then also the court will have will be very, very hesitant to enforce such a non-compete because again it completely makes it difficult for the party, the employee, to get an alternative employment. So therefore, what are the then comes the question: what kind of non-competes will the court enforce? The courts will enforce non-competes ideally in situations where the non-compete clause is fair. It is for a reasonable time, let's say 1 year, 2 years, 3 years. Number one. Number two, where the non-compete is very specific, that it is with my competitor with whom you have dealt with, or with my customer with whom you have dealt with, or even naming the parties. You can't work with X, Y, Z. So case, or where, for example, the employee has himself received, for example, these bonds you give, performance bonds, because the employee has been sent for training or has been shared industrial secrets. So where the courts basically in non-compete situations balance equities. You understand what I'm saying? Balance equities of parties, the employer's equities as well as the employee's equities. It tries to ensure that neither party can screw over the other. Neither can the employee be smart, gets the training from the employer, is sent abroad, is given all the confidential information, is given training, and next day he runs away with that to a competitor. Similarly, at the same time, it cannot ensure that the employer creates such a vast and such an unfair non-compete clause that any employee who leaves that job then can't get employment anywhere else. I hope I've been able to address.
No, yeah, yes, I mean, generally, yes, we got it. I mean, we totally, I mean, reasonable clauses, kind of where the employer has invested and has secrets or information. I mean, that too, which is not in the public domain, is a confidential information which has been passed on to the employee. With those circumstances, and direct competition will not be able to join, which is that's what I understood from comments you made. So how is it? I mean, some companies they do like, I mean, if you are a company A, you cannot go to company B. Can they say that one? Can they document it in the offer letter and say that you cannot go to this I'm in a company A. I'm doing the same thing. I'm dealing with the same customer, and they will say that if you leave me, you cannot go and work for company B.
Well, as I said, that again, it will depend on the facts of each case. I can't, unfortunately, give you a general comment or opinion on that. You'll have to see the kind of equation between company A and company B, if they are traditional competitors, if there is some kind of special secret which has been shared with the worker, with the employee. So these are the factors which have to be kept in mind. Otherwise, you always have people from Pepsi joining Coke and vice versa, right?
Yeah.
So again, as I said, it will depend on the facts of each case and the unique situation of the kind of work the employee was doing. For example, let's say the employee is working in the research component of Coke, or whatever soft drink company, and then is taking that research and going to another research wing of the competitor. So it's a circumstances of each case.
Gotcha. Thank you very much. And I mean, coming back to the notice periods, I mean, nowadays we are seeing, I mean, 90 days notice period, 60 days notice period, those kind of things. Is there any legal statute in India? They said the minimum here, and we can say 2 weeks notice, maximum 2 weeks notice. I mean, we have to give either side. Sometimes, I mean, if I give a 2 weeks notice to my employer, I mean, he may terminate me immediately too. I mean, he may not wait for 2 weeks. He will say that, okay, why don't we terminate immediately? He will say that he will make a decision and will say, let's do it in 24 hours or 48 hours. That's how they terminate here. What is the statute in India about the termination clause? Especially in the IT or non-IT, yes, sorry.
So far as India is concerned, as I said, in the Indian ecosphere, unemployment ecosphere, the employees are divided into two kinds. People who are workmen under the Industrial Disputes Act. And as I said, don't think workmen as working in a factory. Because now with the Supreme Court judgment, as I said, even a priest in Tirupati might turn out to be a workman, okay? A person who's making a laddu in the Tirupati temple will also be a workman. So a workman under the Industrial Disputes Act is entitled to 1 month's notice if the unit is less than 100 workers, or 3 months notice if the unit has more than 100 workers, or pay in lieu of notice. So you need not forcibly make him work. You can just give him that money of 1 month and say go. So far as private employment is concerned of non-workmen who are not governed by the definition of industry and workmen under the Industrial Disputes Act, they are completely governed by the Contract Act. So it is up to you, both parties, to decide on what kind of some have 6 months, some have 1 year, some have 3 months, some have 1 month. Most common is 1 month. Interestingly, pilots in India are also workmen. Pilots, courts have held that pilots are also workmen. And you may be aware that many airlines actually take these kind of undertakings from pilots that they can't quit without 6 months notice. So what I'm trying to say is that it depends on each industry practice and it depends on each employer. There's really no law for a non-workman in India.
Okay. So how does it work? I mean, let us say if I have a 6 months contract, a termination clause, or 3 months termination clause in an IT company, and if my employer comes back and says that I'm terminating you, in 1 week notice. So what are my rights? I mean, do I get the salary for next rest of the 2.5? I mean, 2 months and 3 weeks, or how does it work?
Absolutely. If the person is not, if the employer is not giving you that 3 months notice, again, I must caution you, it will also depend on how the employment contract is worded. That also have to keep in mind. But normally, though I have seen certain exceptions, but normally the employment contract provides either or, that it can be notice or pay in lieu of notice. But some employment contracts mistakenly or by practice don't have this concept. But yes, if there is pay in lieu of notice, the employee who gets short notice is entitled to that differential notice in the form of payment compensation.
Okay, so can some agreements can be like this? If the employee has to leave, I mean, he has to give 3 months notice, and if the employer has to terminate, they can terminate in 1 week notice. Can the contract be like that?
Yes, again, it's a matter of negotiation. It can be there. Also, different kinds
So
of employees can have different kinds of notice period. As you know, a probationer can have 1 month, a confirmed employee can have three months. So even different kinds of employees can be given to different kind of notice periods.
So
sorry, what I'm saying is that so far as this requirement of working, now keep in mind also that the employee can also say that though I have to give you 3 months notice, I can't give you because I've got a better job. You can deduct my 3 months pay from the final payout that you were going to give me. So even an employee can sacrifice his 3 months pay. I was giving you the earlier example of the employer giving you 3 months pay because he doesn't want you anymore. Similar, it can be the other way also, that the employee can also say, okay, I know I was supposed to work for you for 3 months, but I can't work. You know what? You take this 3 months, deduct this 3 months of my salary from my whatever you were to pay me, and I'm leaving today.
Oh, okay. I mean, but he will be losing his previous salary.
Yes, it's not salary, but because salary is already paid, so it will be adjusted against his pension, gratuity, retirement, leave encashment, unclaimed benefits, etc.
Gotcha. Okay. And I mean, is there any concept of severance in India? Like, not only the big corporations, even in the US and big corporations, they do it because of the lawsuit, they're in fear of lawsuit and those kind of things. They do pay out. Per 1 month or 1 year, they pay you 1 week salary. I mean, depending on the financial situation of the company. That is, I'm terminating. An employee who was there with us for 5 years. And if you're sending him off, then they will pay him at least 5 weeks of severance.
Yes, again, as I said, in India we have difference between workers and not workers. So far as workers are concerned, workers are entitled to a retrenchment compensation. In India we call it retrenchment compensation, which is 15 days pay for every year of service. So for example, if you work for 1 year, then you get 15 days of your salary as a severance compensation. You work for 2 years, then you get 30 days. You work for 3 years, then you get 45 days. So it's 15 days for every completed year of service is given as a severance package. And 1 year is considered 240 days. So if you worked for 240 days in 1 calendar year, it is deemed that you worked for 1 year. If you work for less than 240 days, then that year doesn't count. Then that doesn't mean that you worked for a year.
Gotcha.
But this is for workers. But so far as non-workers are concerned, there is no such law. It is again dependent on industry practice of what kind of golden handshake or severance you give. The law doesn't require you to give anything.
Got it. So the IT sector doesn't come under the labor laws.
Oh, well, we don't know. There are certain parts of the IT sector might just come. As of now, techies may not technically. There is no adjudication as of now because of the high turnout rate of this sector. But for example, let us say in the IT sector, there is a receptionist or a clerk or a driver or a peon or an office boy. They are all working in the IT sector. They may not be doing the techie work, but they are covered, and they will be under the Industrial Disputes Act entitled to payments of severance.
Okay. So the non-IT people are. So why is the difference? I mean, to the IT and non-IT people. Any specific reason?
No, again, it depends on whether you are governed by the definition of a workman. And in the Industrial Disputes Act, Section 2S, the definition of workman has been given. The workman, so any person, as I said, and that has been, even a pilot of Air India has been held to be a workman, okay? So a workman, if you are doing any kind of manual, clerical, operational work, you become a workman. But however, if you have supervisory work, for example, if you're a team leader in an IT sector, you are supervising 5 techies, then you're a supervisor, then you're not a workman. So then you may not get the severance pay. But a coder, a programmer, as of now, it is debatable whether the coder or the programmer would come in as a workman or not. To my knowledge, I may be subject to correction. There is no authoritative ruling of any High Court or the Supreme Court on whether a coder or a programmer, an IT professional, is a workman or not.
Oh, okay. So there is no.
I'll tell you why this is not there. It's
Sure.
because the IT professional would rather go and take another job than be litigating and going to court and getting a judgment after 15 years from a Supreme Court, after having fought in a labor court, High Court, and then Supreme Court, to get a declaration that you are a workman. And mostly in industry, this is done with the help of trade unions. Now, because there is no trade union culture in IT companies, so therefore there is no trade union also to handhold a retrenched techie. He is busy finding another job.
I got you. I mean, again, the free market kind of environment is helping the IT sector. I mean, the demand and the supply. But today, during the pandemic and during the tough times, that scenario will be a little different. I mean, the companies are, trying to look for the ways to cut down the costs. So I'm sure there will be many. As of now, what I've been hearing is there are no layoffs. In a large scale in the bigger companies, but in small companies, they are, probably letting some people go. But I'm sure there will be some layoffs in the coming months. So do they have any rights when they do get laid off?
As I said, it will again depend on whether they are willing to take it to court and litigate and say that I should get, if they claim that they are workmen, then they have to claim retrenchment compensation. If they don't get it, then they have to litigate it. I don't know, there may be litigation in the future with the pandemic. A lot of people, IT professionals, may not find an alternative job, and they may have time on their hand to say, hey, you know what, let's litigate. So you may just get your first case where the courts may hold one way or the other whether an IT professional is a workman or not. Now, so far as layoff is concerned, again, it will depend on what is the industry practice, which is, it's too early in the day to say how it will work out, but many companies are coming up with friendlier and employee compassionate exit policies also. Some are giving, some are agreeing to reduced pay, some are agreeing to unpaid leave, and some are agreeing to a negotiated exit. Of course, there are many who are just simply being sacked.
Gotcha. Thank you very much for your views on these topics and especially your legal opinion, or I would say legal only suggestion and opinion. It's not a legal advice, anything of that kind, which we totally understand. I'm switching to another topic. Do you want to take the sexual harassment or the domestic violence? I know we have only 15 minutes left. We are already 45 minutes.
These are both very, very important topics. I don't mind I've worked on both these issues, so you can ask me on any of this.
Just one quick question on the sexual harassment. As we've been talking about the IT industry and all those things in India. So I don't think, what we have been hearing is not many cases come to the court. Is that true?
Not really. Now, since the Sexual Harassment Act is law, Many cases are coming to the district authorities, to the high courts. It is being litigated. Of course, it will take time. The culture of actually coming forward and making complaints of sexual harassment is just getting established. There was also a lot of stigma in this issue. A woman, see, any worker who litigates, has a tag that this person is a troublemaker. And when you are a lady and you are making a complaint of sexual harassment, there's a double tag. That not only are you a troublemaking employee, you are also that kind of woman who is going to make an allegation. And unfortunately, that stigma never comes to men, it always comes to women. And therefore, a woman thinks a lot before she actually has the courage to come forward and make complaints and even litigate. So, because these are new laws, and again, with all legislation making in India, there are many loopholes. There are many things which, of course, in this 10 minutes, you have to have another meeting and call me again to discuss this in detail. But there are a lot of pitfalls and a lot of potholes. But still, it is many people are coming and litigating. But the numbers are trickling. They will increase over time.
Yeah,
and many employers are also becoming very conscious of the law of sexual harassment. A lot of companies, especially MNCs, software companies, are engaging sexual harassment legal professionals to assist them in formulating their human resources policies, in formulating their policies to deal with sexual harassment, in dealing with conducting sexual harassment inquiries. So positively, a lot of employers are also buckling up and preparing themselves to deal with this issue.
Gotcha. I mean, I know as you said rightly, I mean, this subject itself is a big vast one. I mean, so we need to come back again and revisit this, but to talk about this one on another show for sure. Let's go back to the domestic violence, I mean, which is also, I mean, very important in India. And also during the pandemic, I mean, more people are home, so there is no workplace issues right now, but the last 2-3 months. And right now, the domestic violence, I mean, how is the domestic violence during the pandemic time?
Well, there is no effective data on domestic violence during pandemic, but there were a feeling, many experts felt that being locked in with the abuser would of course increase the domestic violence. There was a petition filed in the High Court of Delhi also asking for more effective steps to be taken to deal with domestic violence. As a result of that petition, courts started hearing domestic violence cases as also urgent cases during the pandemic. Earlier it was not being done. So this led to even DV cases being dealt with. One important thing you must keep in mind is another aspect, another facet of the pandemic is the industrial job loss and migration. So as a result of that frustration, a lot of these industrial workers would take out that frustration in the form of violence against their spouses and female dependents. So yes, this is a very important issue. But unfortunately, the domestic violence law depends on the institution of protection officers, which are created by the Domestic Violence Act, who are supposed to be like the friend, the hand holder for the women who face violence. And unfortunately, most states, I can give you an example of Delhi, a city like Delhi has only about 16 or 17 protection officers. Whereas you actually need in every locality one protection officer so that women facing violence can reach out to them. So in India, we have the law of domestic violence, which has been there for a while. But however, most governments are not putting their money where their mouth is and actually taking concrete steps to effectively operationalize this legislation.
So what are the women right? I mean, are the spouse, I mean, he or she, I mean, victimized? I mean, so what are the rights they have? I mean, what kind of rights do they have?
Well, under the domestic violence law, which I may tell you, I had also the privilege of being part of the campaign and drafting this legislation. Two things I want to tell you. The Domestic Violence Act has expansively defined domestic violence to include sexual violence, psychological violence, economic violence, physical violence, verbal violence. So that's number one. Number two, a lot of rights have been granted under the Domestic Violence Act, like the protection order, that you can go and take a protection order that he will not commit any violence. A residence order, that you can go and get an order that I will not be thrown out from this residence, or that the husband will make available a residence for me. Then a child custody order. You can, under the Domestic Violence Act, also get an order for child custody. You can also get an order for economic protection order. You can also get an order under the Domestic Violence Act directing the husband to pay for your maintenance. And the last, under the Domestic Violence Act, you can also get a compensation order. For example, if you had to be hospitalized, let's say that your husband burnt you with acid or beat you up, so you had to be in the hospital. So even the hospital expenses, medical expenses, you can claim by going under the Domestic Violence Act and just simply filing an application. So there are a lot of remedies available under this law. It's just that we have to operationalize this more effectively, have more courts, and have more protection officers to assist women.
And I mean, when you say the economical benefits, so how are they claiming? I mean, how do they get the benefits? I mean, let's say they have a compensation benefit, so they need to enforce. I mean, if it's working in most of these domestic violence cases, I know there will be the middle class and higher class too. But are they cases in the lower class? I mean, economical class or middle class, middle income class group, or high? Where do you see these cases mostly?
See, the unfortunate or fortunate thing about domestic violence is, unlike everything else in India, which is class, caste, and religion based, domestic violence loves all. So you have domestic violence in every faith, in every caste, and in every class strata. So you have the richest of the rich, Hindu, Muslim, Sikh, whatever, Parsi, everywhere there's domestic violence, and in every strata. But yes, you're right. When it comes to the lowest strata, let's say a rickshaw puller, a small trader, roadside trader, it becomes difficult. Enforcement becomes difficult because obviously, even if you can get an order of maintenance or an economic compensation order, what will you get the compensation from? So this is where the role of a protection officer comes in, because a protection officer is supposed to coordinate with all the other service providers like NGOs, shelters, skill building professionals, mental health professionals, to be able to give that kind of support to the victim of domestic violence, who may not get that support directly from the abusive spouse.
Gotcha. And so many other, and at the same time, I mean, when you are the lower income, I mean, the awareness is they don't have enough awareness, and they may not have economic resources to go and file a complaint. And I mean, the case won't even come to the court, if I'm not wrong.
Yes. Can I just interrupt and just say one
please.
thing? When we drafted this law, we were very clear, and this is one of the only Indian legislation. We were also influenced by the Violence Against Women Act of of the US.
Yes. Okay.
So we had put in two things in the draft. One remained, one the government chopped off. One was that there will be an obligation on the government to create wide publicity of this law. So it is the obligation of the government and its instrumentalities like the police, the ASHA workers, the health workers, to actually go and disseminate this information to everyone. The second thing we had put in, influenced by the Violence Against Women Act, was that the government will every year also put money to do this, and that they chopped. They said, we will not give money. We are making the law, but we will not give any money. So to answer your point, this law actually requires the government to create that awareness. This is the first legislation in India where the obligation is given to the government to make people know about this law. The other thing you have to keep in mind is the way this law is structured is that if all these orders which I was telling you about, protection orders, residence orders, are not implemented, honored, then the victim can actually go back to court and make a complaint that this order has not been honored by the abusive partner or spouse or the person, and then that becomes a criminal offense, and then that person can be criminally prosecuted, and a warrant of arrest can be issued against that person. So this actually tries to marry civil law and criminal law. It makes domestic violence a civil wrong, gives certain civil rights, civil relief, civil remedies to the victim. However, once the civil order is not implemented, that non-implementation or disobedience of that order becomes a criminal wrong under the Domestic Violence Act.
Gotcha. And another point, I want to ask, I know that the number of cases in the domestic violence, we are seeing, mostly the women are being victims and the very less cases of the men being the victim. So is the women are being victim, is it because of their, they are not being economically free, or they are not independent? Personality wise or financially, are not well educated, or is that or is that the main reasons, do you think, they are being victims in this domestic violence?
See, when this law was being drafted, there was a certain section of the population, mainly men, who wanted this law to be unisexual, meaning it should it's sex neutral to cover both men and women. They said that even men face domestic violence. Why should men be covered? But mercifully, the law is actually sex specific, and only women victims can actually come to court.
Oh, okay.
And let me tell you that this law has again been so this also, the law also says that not only the women victim can come to court, the respondent can't be a woman, because otherwise in India the mother-in-law daughter-in-law issue would be used, and the husband would use his mother to file a case against the wife by saying that this wife is taking is causing trouble for me. So you have to also keep in mind the unique situation of India. Now, to answer your point, of course, it is the economic disadvantage of women and the social disadvantage of women, because even in why domestic violence in the upper class, upper segments, when there is no such economic difficulty, it is because socially women in India have for years and years and generations been, whichever strata of society they are, whichever that they are inferior, they are dependent on men, they get their entire status and identity from men, and therefore they are the ones who are most vulnerable to violence. Including, you will be interested to know that we had also provided, and it is there in the Act, that economic violence includes nutritional discrimination also. For years, many people in India did not know, many women did not know why she is getting less food than her brother. They didn't even understand that that is domestic violence. But now the law makes that nutritional discrimination also domestic violence, that a woman cannot be treated differently and cannot be given less food.
Yes, less food. Gotcha. That's very nice. So the crux is, it looks like, in India, if you probably before getting into the domestic violence, the NGOs should, NGOs are working, of course, and probably more. We need to emphasize more on. Empowering the women to become a self-sufficient, but let it be financially or emotionally or from knowledge point of view. So probably that should be am I right in the triangle?
Sorry, I didn't get your question.
Oh, what I said is, in India, with the NGOs or the government or the society should be working towards empowering the women.
Absolutely, absolutely. And a lot of steps are being taken. I think our Prime Minister's initiative to give the gas cylinders through subsidy was a big thing, which led to a lot of self-empowerment of women. Creating self-help groups, which have started even from the previous government and continued by this government, is also a very, very good step towards the empowerment of women, and more has to be done. Lots and lots of work is there. A lot of homework has to be done.
I know. Very nice. Thank you very much for all your views and the opinions. So do you have any message to our audience or listeners, Mr. Sanjay Ghosh? Please.
I want to say I want all interviews to be as sweet and as responsive and as attentive as you. I really enjoyed discussing with you. I think we covered a lot of important issues. Thank you so much for having, and I want everyone to be cheered up during this pandemic. It's creating a lot of anxiety, a lot of mental issues, physical issues for people. I would just like to say, keep the faith, be strong, and I'm sure we will all together triumph, because human nature always triumphs over all kinds of adversities. So keep hanging on.
Thank you very much for your time and coming onto the show, Mr. Sanjay Ghosh. Have a nice rest of the evening. Thank you.
Thank you.